trickling in, but they'll just miss my introduction, which is fine. So thanks so much to everyone for coming. I'm Mallory Harris. I'm a third-year PhD student in biology studying infectious diseases, and I'm also the co-president of Scientists Speak Up. We're a student organization here at Stanford that helps people learn how to advocate and communicate effectively about scientific topics that are seen as controversial. Since this is our last event of the academic year, I just want to take a quick moment to kind of reflect on what we've done so far and where we've come from. And to start off, I actually want to share a personal story that I think kind of helps contextualize this event and take us back to August, when despite the rollout of an effective vaccine against COVID-19 in the United States, we were experiencing what ended up being the most deadly wave of the entire pandemic in the United States, sparked by the Delta variant. And this affected me personally. I lost a family member who had decided not to get vaccinated. And afterwards, his wife, who was also unvaccinated and had a severe case, explained to us that they had done their research and based on that decided not to get the vaccine. And I've seen kind of like that's become a little bit of a joke or a refrain, this idea of someone doing their own research and deciding not to get vaccinated. But I think it's really a sign of something pretty bleak that's happening. Like, how have we reached a point where people wanting to make the best decision for themselves and their families could, trying to be informed and empowered and seeking out this information, reach a conclusion that was so devastatingly harmful and so out of sync with the body of scientific research confirming that these vaccines are safe and effective? How did our information ecosystem become so damaged? Scientists Speak Up has been a way for me to try to answer these questions and learn amongst my peers. We started out this year taking a closer look at why harmful misinformation spreads online and understanding the roots of historical, deliberate disinformation campaigns that work to undermine the science, showing fossil fuel emissions cause climate change. We've also had workshops to learn how to communicate our science more effectively, learning about writing op-eds and how the Intergovernmental Panel on Climate Change works. We've also spoken some about directly responding to misinformation, whether it's through debunking on social media or having one-on-one conversations where you come from a place of empathy. But I think it's also become increasingly apparent that the solution here isn't just going to be individual scientists speaking up. Like, it's really going to take all of us across disciplines. And earlier this week, we heard from medical historian and bioethicist Harriet Washington about her work uncovering instances of medical abuse and environmental racism and advocating for more ethical safeguards. We'll conclude this year with this talk that I'm really excited for, thinking about the additional policy and legal levers that we have to intervene in instances of medical misinformation. I know this is an issue that a lot of us care about and a lot of people have been touched by personally. There have now been several papers estimating that over hundreds of thousands of people in the United States would still be with us today if they had been vaccinated. Many of these people were victims of medical misinformation. And so a lot of us are searching for workable solutions and trying to demand accountability, but also wanting to make sure we maintain free and open scientific discussion. After all, we're called Scientists Speak Up. So on behalf of Scientists Speak Up, as well as our co-sponsor for this event, the Stanford Medical Student Association, I'm excited to welcome you to our panel today to learn more about how we can mitigate the spread of medical misinformation. And we're going to start out with Michelle Mello, a professor of law at Stanford Law School and professor of health policy at the Stanford University School of Medicine, where she conducts empirical research into issues at the intersection of law, ethics, and health policy. She's the author of more than 230 authors on medical liability, public health law, the public health response to COVID-19, pharmaceuticals and vaccines, biomedical research ethics, and much more. the recipient of a number of awards for her research. She was elected to the National Academy of Medicine at the age of 40. She holds a JD from the Yale Law School and a PhD in Health Policy and Administration from the University of North Carolina at Chapel Hill. She also serves on the Lancet Commission on Vaccine Refusal, Acceptance, and Demand, and has written extensively on preventing the spread of medical misinformation, including pieces in JAMA entitled When Physicians Engage in Practices That Threaten the Nation's Health, and Vaccine Misinformation in the First Amendment, The Price of Free Speech. So with that, I'll hand it over to you, Michelle.
Thank you for that and for having us today. And I also want to thank you, Mallory and Santiago, for your activism more generally. I think anyone who works in the misinformation field knows that it takes both spine and very leathery skin to be able to work in this area, and really appreciate all of your efforts. I thought I would focus today on helping folks understand the legal boundaries around what we can do to regulate vaccine misinformation in the US, because it's an area that people don't tend to understand very well, mostly because they think, well, misinformation, that's just lies. That can't possibly be protected by the First Amendment. But as I'll explain, often it is. And this is really important. We know that up to 12 million people have forgone COVID vaccinations because of misinformation. That's 1,200 extra hospitalizations and 300 extra deaths per day during the pandemic. That's equivalent to 5 fully loaded 747s crashing every week. And if that happened due to wrong information, you could bet that regulators would be all over that, but they're not in the case of vaccine information. And instead, our primary response is just to pump out better information into the marketplace of ideas and hope for the best. Now, that's not a foregone conclusion. Other countries around the globe have taken other routes. They've gone so far as to criminalize the knowing spread of misinformation. For example, Germany penalizes social media companies up to 50 million euros if they fail to remove hate speech or fake information within a day. So there are other possible routes. Why don't we move more aggressively in this space on a legal level, given the social cost? What I want to convey is that it is because of our Supreme Court's attachment to a particular conception of First Amendment rights, of free speech rights. Basically, although some kinds of false statements lie outside the ambit of the First Amendment, many other false statements actually enjoy constitutional protection. And I'll make the argument, which I hope will provoke discussion because it is provocative, that the court should do more and could do more even within the boundaries that it's already set out for what is permissible. So first, what does the Supreme Court protect right now? Well, in a 2012 case called United States versus Alvarez, the court struck down a federal law called the Stolen Valor Act, which made it a criminal offense to lie about getting a military medal. The Congress's intent in passing these laws was to preserve the integrity of military medals generally. And this case involved a guy who was a habitual liar and got up in front of a meeting of his water district board and claimed to have won the Congressional Medal of Honor, a patent lie, easily exposed. He was prosecuted under the Stolen Valor Act. He pleaded guilty, and then he appealed on the basis of his free speech rights. What was going on in the Stolen Valor Act is what lawyers call a content-based restriction. It's a speech regulation that only gets triggered if you say something about a certain subject or topic or viewpoint. And that kind of restriction is something the court has a very difficult time accepting. It applies its highest level of judicial review, what we call strict scrutiny. And in order for the government to sustain its regulation, it has to show that it has a compelling purpose and that there's no other way to achieve that purpose that burdens speech less. That's a really, really high bar. And the court held in Alvarez that it wasn't satisfied, even though protecting the integrity of military medals was a compelling purpose. The government could do other things to do that, like just expose Mr. Alvarez as a phony or create a database of all the real medal winners. And as long as that's the case, the court's not going to uphold the restriction. Now, the part of that case that's especially important for our discussion today is that the court refused the invitation to find that just because Mr. Alvarez had told a lie, that statement was wholly outside the ambit of First Amendment protection. Now, the court recognized that it does actually allow lots of kinds of restrictions on false speech. For example, lying in court. That's perjury. It's a crime. Making false statements to the government more generally, for example, on your tax form. Impersonating a government official, like a mailman or police officer. Defaming somebody, telling lies about them to damage their reputation that you know are false. Or committing commercial fraud. And that last category is useful for our discussion today because that's what the FDA uses to go after health products companies that make unsubstantiated claims that their products will improve your health. And it's what the Federal Trade Commission and state attorneys general use when they go after companies for deceptive advertising and marketing practices. There's also latitude for regulating the speech of medical professionals, something that I think Dr. Nichols will talk about today, because courts have held that boards of licensing can suspend the licenses of physicians for unprofessional conduct when they make statements that are so false and outrageous that they rise to that definition of unprofessional conduct. So all of these pass this legal test of strict scrutiny. And the kinds of reasons that the government has for adopting these restrictions on false speech are things like protecting the integrity of government processes like trials, and preventing people from gaining a material advantage by deceiving others, and just more generally preventing what it calls tangible harm to others. Okay, so that's the background. That's what we're dealing with in terms of the legal guardrails. Now, why does the court take the position that lots of other forms of false statements are protected by the First Amendment? Well, the feeling is that even lies can be valuable in surfacing the truth. In our marketplace of ideas, we want to enable people to feel free to challenge widely accepted beliefs without fear of legal repercussions. And things could go pretty wrong if we gave the government more latitude to declare certain topics or positions off limits. So why might that be? Well, one reason is that we might not all agree on how demonstrably false something is. And that's certainly true in the case of vaccine information. There are some things about vaccines that we can prove are false. And there are other things that it's just the case that people can't really prove to be true. So it is not a black and white situation. A second problem is that in scientific matters, the knowledge base that makes something true or false will evolve over time. That makes things tricky. A third problem is that some people disseminate misinformation knowing that it's false, and lots of other people disseminate it thinking that it's true. You know, in contrast, in a lot of areas where we regulate false speech, there's kind of a standard that people know that they're lying. And then finally, and I think most importantly from the court's perspective, many people just don't trust the government to decide what is off limits. They think that that power will inevitably be abused. And indeed, in this Alvarez case, the Supreme Court cited from George Orwell's 1984 and the Ministry of Truth in Oceania to sort of raise the specter of government abuse. So all of these are reasons why the court is really wary of allowing governments to regulate false information. So let me conclude just with an argument here. Now, departing from what is to my view of what ought to be, I think these problems also apply to areas where the court does allow restrictions of false statements, and that lawmakers generally have found ways of addressing them. For example, if you're worried about people who spread misstatements unintentionally, thinking that they're true, you can have a law that says you have to have a certain state of mind or knowingness before you can be criminally prosecuted. So I think that when courts really see a need to regulate false speech, they will sort of acknowledge that there are, in fact, these brakes that we can put on abuse of power. And I think that the case for regulating vaccine misinformation is actually a lot stronger than the case that the government has for regulating some of these other forms of false statements. You know, for example, let's think about FDA's ability to regulate false claims about diet pills or dietary supplements, for example. Now, the court allows this, even though it's certainly the case that the FDA could and does issue statements trying to debunk those claims. And that's a case in which the court isn't going to look too hard at whether this so-called counter speech is an effective remedy. And it probably is a fairly effective remedy. You know, if you're going to use a new health product like that, you might well be relying on the FDA to tell you whether they think it's safe and effective. So why shouldn't that same rule that says we can regulate statements from health companies in those circumstances apply to other speakers? Why is it that a pundit on television can say the exact same thing about a health product and have that to be protected speech, whereas a company cannot? Again, the argument can't be that there's not another way to deal with the claim, because it's the same situation. Similarly, let's look at the severity of the interests at stake. In a lot of these situations, the government's purpose, you know, the court calls it compelling, but it's things like, you know, making sure government processes can function efficiently, or preventing consumers from being bilked out of dollars they spend on dietary supplements. We're talking about massive loss of life in a global pandemic, perpetuating a pandemic that itself causes disruption of government processes and economic losses, as well as loss of life. So I think the case is just overwhelming. If you're going to sort of base it on a harm argument, we ought to be thinking about this as well. So the harm argument, I think, weighs in favor. The lack of other alternatives, I think, doesn't distinguish these cases. And indeed, for vaccine misinformation, one thing we know for sure, these beliefs are extremely difficult to dislodge with additional information. They are very persistent. They spread through social networks like wildfire. And once they take root, as anyone who works in this area will tell you, there is almost no chance of persuading someone otherwise. So for these reasons, I think this kind of restriction, which is to say a limited rule that if you knowingly spread information that you know to be false about vaccines and it materially influences people's vaccination decisions, that speech can be restricted, penalized even, is defensible and passes this strict scrutiny test. We've got a compelling purpose at stake. And because counter speech just does not work, and the courts are supposed to be limited to considering effective alternatives, not just any conceivable policy alternatives, but only things that are plausibly effective, there's not a less restrictive alternative here. Now, I'm not going to convince the Supreme Court of this anytime soon, or anytime in the conceivable future. There's simply too much willingness on the part of the court to believe litigants when they come before the court and say, oh, there's another way. We can just inject more speech into the marketplace of ideas. And so as a result, we are going to continue to be very, very vulnerable to health threats that spread when people have wrong information. And in a sense, what the government has done here is essentially punted over to social media companies to do the job that they cannot, because government is restricted by the First Amendment. Social media companies are not. And so that is the state of play in terms of the law here in the United States. And it's what makes what Evelyn's going to have to tell us so important. Thanks very much.
Thank you so much, and thanks for teeing up that great transition into the next speaker, Evelyn Douek, who has an SJD from Harvard Law School and is currently a senior research fellow at the Knight First Amendment Institute at Columbia University. And she will also be joining us as an assistant professor in fall of 2022, which Michelle was saying has just been made official, and I may be one of the first people who gets to introduce her with that title, so I'm very excited and honored by that. Her scholarship focuses on online speech regulation, content moderation, and platform governance. Her research has appeared or is forthcoming in numerous outlets, including the Columbia Law Review, the University of Chicago Law Review Online, The Atlantic, and Slate, and you should definitely Google her and read those pieces. And she also blogs and podcasts at Lawfare. So I'm going to hand it over to you, Evelyn.
Thank you so much, Mallory, and thank you for the seamless segue, Michelle. You wouldn't be able to tell it because of the extremely reasonable and logical way that Michelle just outlined that argument, but it was actually a pretty controversial argument. I made an argument a week or so ago in a blog post, something along those lines about the regulation of false speech, and it initiated quite the Twitter pile-on. So, lawyers are a fun bunch. Can you see my screen okay? Okay, so as Michelle was saying, the capacity for the government to regulate misinformation is highly restricted, especially in the United States. It's also true that it's restricted in many other countries countries as well. And so this has really increased the pressure on platform companies and private companies to take up the mantle. And it's also true that, just in general, private companies can be more nimble and be more responsive to rapidly changing circumstances than a government legal bureaucracy might be able to. So there's all sorts of reasons why people might turn to platforms. Historically, however, platforms have really not wanted to take up this responsibility. They have, for a long, long time, there's this statement, it's most famously associated with Mark Zuckerberg, but pretty much every major platform has said some variation of this in the past, which is, we don't want to be the arbiters of truth of what people say online. Who are we? Who are we to decide what is true or false?
Evelyn, can I jump in really quickly? I think some people are having some difficulty hearing you, so maybe if you turn off your video and we'll try to see if that helps bandwidth-wise. No, maybe here. Let's give it a second. Maybe here.
I just put my headphones away. Is that any better?
Yes, that's really good. Yes.
Okay. Let's stick with that then. Okay, so platforms didn't want to get in the business of deciding what is true and what is false. Then came the pandemic. And I don't know if, all of you will remember this better than I, but there was this word being thrown around a lot at the start of the pandemic called the infodemic. I actually haven't heard it in a couple of years now, but it was the way in which authorities were describing this flood of mis and disinformation that was outpouring at the same time as everyone was trying to make sense of this new reality. And that caused platforms to rapidly change their position on policing misinformation, literally overnight. They'd gone from this, we're never deciding at all, to rolling out some pretty aggressive policies around this. So they took two exceptional measures as a result of the pandemic. The first was much more aggressive misinformation policies. And the second was much more reliance on artificial intelligence tools to enforce those policies, because they, like the rest of the world, had to send all of their workers home. They couldn't work from the office. And this meant that they had much reduced capacity in human moderators. And so they had to rely on their artificial intelligence tools instead. So the main justifications that they took for this in the context of the pandemic, the first was the imminence of harm. And as Michelle was pointing out, that's a really important kind of criterion for when we're thinking about what kinds of false speech should be restricted and what should be not. And the second that they relied on a lot, the platform still sort of said, we don't want to be arbiters of truth, but at least in this health misinformation context, there's these like consensus around authoritative sources that we can look to who can tell us what is mis and disinformation. So we won't decide, but we'll point to authorities like the World Health Organization, for example. So they rolled out these extensive policies that sort of along those lines. Here's Facebook saying they're going to start removing false claims or conspiracy theories flagged by leading global health organizations. Twitter expanded its definition of harm. I don't expect you to be able to read that, but you can see a very long list of dot points underneath that suggests that they're removing a lot of stuff. YouTube similarly rolled out a new policy as well. And then they said, we're going to use AI tools more to enforce it. And then this thing happened, which we hadn't really seen in this space before, which was that they said, look, because we're going to use our AI tools more, we're going to make more mistakes. These tools, they don't understand context. They are pretty dumb, and they're just going to remove a bunch of stuff because they're looking for keywords rather than actually understanding what the posts say. This was actually pretty amazing to see the platforms say this overtly, because for a long time they've been telling us that these tools were magical and we're going to solve all of our content moderation problems. And then when push came to shove, they were like, actually, maybe not so much. So this was the world that we were living in. And this happened in March or so. And suddenly there was this like couple of weeks where the platforms were good again, right? Like everyone was like, let's get back on Facebook. The Facebook's more trustworthy than the president. There's like speculation that coronavirus had killed the techlash because finally these platforms were standing up and taking their responsibilities seriously. It was pretty laughable. I was sitting there just like with the popcorn going, how long is this going to last? And of course, we all know now sitting here, no way, absolutely not. Did this solve the tech industry's woes whatsoever? That's for a number of reasons. The first is the enforcement errors that the platforms predicted definitely came to pass. So I'm going to use in this presentation an example of the mask, of how platforms dealt with masks. So as you will remember, at the beginning of the pandemic, the authorities were not in favor of mask mandates. And as a result, Facebook went ahead and banned all ads for masks. And when it was trying to enforce this, it made two kinds of mistakes. It made over-enforcement mistakes and under-enforcement mistakes. So it took down volunteer groups who were making masks and sending them out to people because the machine was literally like, masks, get your masks. Okay, I'm going to take down that post because it says masks. But then also, you know, bad actors know how to get around these systems. They find other ways. And so for the people that were looking for mask ads, they could also find them. So turns out they had this rule and they were pretty bad at enforcing it. And then, of course, as the pandemic went on, they had to make some pretty high profile policy reversals, including with masks. The thing about masks was there was this big lag. Again, you'll all know better than I am that the World Health Organization reversed its position on masks well after many of the scientific consensus about masks had changed. But Facebook had tied itself to this mast of the World Health Organization, and so was lagging in many ways. And that, you know, was controversial and cost itself a lot of legitimacy. So this technique that then tried to, you know, establish their legitimacy and avoid controversy actually ended up bringing more controversy. And again, another example here was the lab leak theory, which originally they banned as a conspiracy theory, and then had to reverse course once governments started saying that they might be taking it seriously. These two examples have become part of the culture wars. These are now one of the main things that these stories that like conservatives roll out as saying platforms can't be trusted to do content moderation. They shouldn't be the arbiters of truth. And so, you know, when we talk about like Elon Musk acquiring Twitter and having this whole like it should be a free speech platform, these are kinds of the reasons why, right? These high profile quote unquote failures of content moderation are the reasons why there's this push from conservatives who were generally the people that were being, that these policies affected and having their post restricted. So it's sort of led to this controversy and this pushback, this cultural shift around platforms. There was also this problem of like, what authorities, right? So the World Health Organization obviously took a lot of blows to its legitimacy over the course of the pandemic. But then there was this problem of like state government authorities, local government authorities, other countries, where places, you know, had differing views, were sprouting quote unquote misinformation or disinformation themselves, but they're governments. And you have this weird tension of like a private company like Facebook saying, oh, a Brazilian state government can't be promoting its policies on Facebook. This is an example of a case that the Facebook Oversight Board heard. The Facebook Oversight Board is this weird quasi-independent court-like institution that Facebook has set up to decide its policies. And so Facebook's in this weird position where it has like one determination from the World Health Organization about lockdowns, about what is mis or disinformation, one determination from a Brazilian state government, and then one determination from this oversight board thing, which is like 20 human rights experts. Like, who should it be deferring to determine what its policy should be in that circumstance? So, you know, we sit here now 2 and a bit years later, and I don't know what we've learned. I don't know how much we've learned from this like huge experience in content moderation from platforms. We have no idea whether this worked. We have no idea what platforms took down. We have no idea about what the error rates were as a result of this increased reliance on artificial intelligence. This could have been a fantastic opportunity to gather data about all of this, to gather information about how this, content spread on platforms, whether interventions worked, what interventions worked. And because of a lack of transparency, we just don't know anything about this. And I think that's a massive failure. It's both a massive failure of the private companies to share data with researchers, but it's a failure of governments. Like, companies aren't going to do this by themselves. And so I think transparency mandates and mandates to share data for independent researchers is a really low-hanging fruit place to start in responses for when this happens again, or for future responses to medical misinformation. There's still this question of who are the authorities, and that question is harder to answer now than it was 2 years ago. Who do we trust? And that's going to depend a lot on your particular community as well. And so, do we need to start thinking much more about devolution rather than thinking like, let's just all look to the Global Health Organization? Should we be looking much more locally to local trusted sources and things like that? But then, of course, that becomes much more difficult at scale. Platforms have, over the last couple of years, experimented with a lot of solutions other than just taking posts down, right? At the beginning of the pandemic, it was like, this is false, we're going to take it, quote unquote false, we're going to take it down. There's been a lot of interventions now around labeling posts and saying, get more information here. And then on the, at the top of your feed, when you log into Facebook, saying, get more information on the pandemic at the official World Health Organization site, etc. Again, we don't know if that works. When someone sees a label on a post that it's misinformation, do they click on it? Do they not share it as much? All of those questions, we don't know anything about that. And I think that's a real shame, but it makes us feel good to stick a label on something. So, hey, there's that, I suppose. And there's this question as well about whether, censoring things or having platforms intervene builds trust or undermines it, right? There's this for the people who are, doing their own research, as Mallory put it earlier, it's not necessarily clear that just taking things down will necessarily prevent them from, believing false things. It may, in fact, and we have seen in some circumstances, communities that, that just furthers their conspiratorial beliefs because it makes them feel like there's some shadowy central force that is, determining truth and just wants to make sure that they don't know exactly what's really going on. So I think that, again, much more research is needed on that. But I do think, and I've written about this in another context, that I don't know that content moderation is going to save us, right? I don't think that we can content moderate our way to consensus or to sort of a shared reality. I think these are much deeper social problems about trust in institutions and things like that. And that looking to platforms alone to solve it is not necessarily going to work. But that certainly doesn't mean that platforms can't do a lot better, that we can't innovate in the kinds of solutions that they should be coming up with, and that we should know a lot more about what is happening in those environments.
Amazing, thank you. And so now I'm going to pass it to our last panelist, Dr. Taylor Nichols. So we've heard about kind of the potential role of the government, potential role of the social media companies, and our last component here is going to be professional regulatory agencies. So he's going to walk us through that. He is an emergency medicine physician in Northern California. He spent 2 years performing neuroscience research in the Department of Psychiatry at Stanford University. He completed med school at UC Davis School of Medicine, and then did a residency in emergency medicine at UCSF San Francisco General, and a fellowship in health policy and advocacy at UC Davis Medical Center in conjunction with California ACEP. He's been involved in organized medicine since medical school, serving as the representative from his medical school class to the Sierra Sacramento Valley Medical Society, as the representative from his residency program to the Emergency Medicine Residents Association, and now as a member of the Board of Directors of California ACEP and is a delegate to the California Medical Association. He is also a co-founder and chief financial officer of the nonprofit organization No License for Disinformation. So I'll pass it over to you, Taylor.
Thank you, Mallory. So I am the only panelist here who is not a lawyer, although I was raised by a couple, and maybe since I'm here, I should have just gone to law school like my mom always said. And I'm not an academic, but I did sort of bear witness to the trauma unfolding as COVID hit, and I've been interested in the misinformation space for quite a while since I was in medical school. So I have some slides that I'm gonna pull up for you, and I will share these with you as well. So you can access all the resources. There we go. Okay. So Evelyn actually teed up this transition really well without actually knowing it. So thank you, Professor Douek. For this part, speaking of trust, and so so this is by a paper by Joe Pierre. Dr. Joe Pierre is a psychiatrist. He is also on Twitter. If you're on Twitter, I recommend following him if you're interested in misinformation. He's done a lot of research into conspiracy theories and what leads people to follow or believe in conspiracy theories. Prior psychological research had often come at the belief in conspiracy theories from a deficit model. So what that means is that it was inadequate education or inadequate information around a topic that then leaves a gap, a void that people fill. And what he's proposed here is sort of a socio-epistemic or more like a culturally competent model that of both epistemic mistrust and then misinformation processing. Misinformation processing is more of the deficit model from previously, but it includes much more than just a deficit. The epistemic mistrust is the part that Evelyn had mentioned in terms of people's trust being important in terms of whether or not they believe in misinformation or adhere to conspiracy theories. So here's just those definitions. And epistemic mistrust characterized by inflexible thinking patterns. So they have difficulty incorporating new information. This is directly from the paper. Once voices of authority are negated due to mistrust, the resulting epistemic vacuum can send individuals down the rabbit hole looking for answers where they are vulnerable to the biased processing of information and misinformation within an increasingly post-truth world. So I think that's important to understand in the context of society today, in the context of the conversations that we just had about the legal frameworks of social media and the regulation of misinformation, and how that leads us to this post-truth world when people don't even believe our own leadership or what is truth. So enter COVID-19. Here's a quick timeline, but just to keep in mind, in December of 2019, so December 12th actually was the first time China came forward and said there's a cluster of cases of pneumonia and respiratory failure that we don't understand. We don't understand the cause. By almost exactly, by 364 days later, the Food and Drug Administration had authorized emergency use for the first vaccine from Pfizer. So think about that in the context of people who already have a mistrust of governmental authority, of people who already have a mistrust of vaccines. That is incredibly rapid. Now, some of us understand how this happened. Some of us followed Operation Warp Speed, understand that mRNA has been studied as a technology platform for the delivery of medications or vaccines for decades. But if you didn't have that knowledge and you already had the mistrust using that sort of two-part model, that feeds into this cycle where misinformation becomes really sticky. And so that Also, as Evelyn mentioned, the infodemic, enter the infodemic. We all saw how that went. So as misinformation was becoming more and more of a problem, the Federation of State Medical Boards, which is the umbrella body of all of the medical boards of the 50 states, said that healthcare professionals or physicians who are licensed by the medical boards of their states would be essentially punished for or held accountable for intentionally spreading misinformation or disinformation. Now, they tweeted that out on July 29th after the statement was released. They said physicians who generate vaccine misinformation will be disciplined essentially and could have their medical license suspended or even revoked entirely. So that 11 a.m. July 29th. So keep that in mind as we are now a long way away from July 29th, and we haven't seen anybody's license entirely revoked. We have seen a few suspended for spreading disinformation. So when that came out, a colleague of mine who was my fellowship director, Nick Sawyer, some other advocates and activists and nursing colleagues and allied health professionals, a bunch of us came together and we decided we have to do something about the misinformation that is spreading. And the Federation of State Medical Boards has now put out this statement. So let's hold the medical boards accountable to do that. And so people should not maintain their license intentionally spreading disinformation. So we essentially we called upon medical boards and other governing bodies to urgently protect the public from further harm. And the idea being not just the licensing boards, but the American Board of Emergency Medicine, Pediatrics, and Internal Medicine all also issued statements saying that they would revoke board certification for people who intentionally were spreading misinformation. Yet I have yet to see anybody's board certification revoked. You might have seen us in a couple of publications, either referenced as no license for disinformation or mentioned one of our board members. This is our executive director and my former fellowship director, Nick Sawyer, on ABC News. I recommend watching this. It's a long clip about the truth about ivermectin, right? So what does that mean? They dove deep into sort of the issues at hand about ivermectin, and they also have a bunch of the physicians who we would like to have held accountable for knowingly spreading misinformation. We put out a report with the de Beaumont Foundation, which is a leading public health advocacy organization, with essentially 4 main points: that misinformation and disinformation have become a public health crisis, that medical licensing bodies need to investigate and then hold accountable physicians who are spreading disinformation, and we laid out a path forward for them to do that. The argument, the basis of the argument being that state medical boards, as Professor Mello mentioned, already have grounds to take disciplinary action for professional conduct under their Medical Practice Act. So they should have this authority. However, precedent has it that actions taken by the medical board should be on the basis of a physician-patient relationship. So there should be a direct relationship between the person who is harmed and the physician. There is no standard or precedent legally for them to be acting on just spreading public information, which is, we know for a fact with the California State Medical Board, has been something that essentially they've stated has held them back. So what is being legislated in terms of misinformation? And unfortunately, we're going exactly the wrong direction. So on our website at nolicensefordisinformation.org, we have a legislative tracker from the Federation of State Medical Boards on legislation currently being enacted by states that are passing bills that are specifically harmful to the state medical board's ability to respond to physicians who spread misinformation or disinformation, including saying that physicians can't be held accountable for example, prescribing ivermectin. This is an example from Tennessee. The COVID-19 Treatment Freedom Act, which prohibits the medical board for holding physicians accountable for spreading misinformation or for prescribing unproven treatments. So despite the fact that the Federation of State Medical Boards specifically said that state medical boards would hold physicians accountable, there's legislation being passed across multiple states saying that you can't do that. The medical board cannot take action against physicians who spread misinformation. In fact, Tennessee and now New Hampshire are legislating such that ivermectin can be available over the counter by a universal prescription. So further harming the efforts of trying to allow the medical boards to essentially do their job. Now, California, of course, is going a little bit the other direction. They're trying to help bolster the medical board, as they've said, you know, here's the precedent and there's no standard by which we hold people accountable for just their speech, right? Saying something on Twitter or in a public forum. So AB 2098 would make the dissemination or promotion of misinformation or disinformation related to COVID a form of unprofessional conduct. Now, they, in our opinion, already have that authority under the Medical Practice Act, but this explicitly makes it clear that this is unprofessional conduct and that what they are doing is effectively violating their practice of medicine as a professional. And therefore, they should be allowed to take action against the license of a physician based on this unprofessional conduct, regardless of whether or not this was in the context of a professional relationship. We've discussed the principle of freedom of speech. Now, the medical board is part of the government. This is speech, so that's been the sticking point. Professor Coleman wrote an excellent paper or article on this, physicians who disseminate medical misinformation, testing the constitutional limits of professional disciplinary action. So it lays out the exact case that we are talking about here. In that, while you could consider this to be part of free speech and that imposing disciplinary penalties on speech outside of that professional relationship could have concerning policy implications, could be considered unconstitutional as a regulation of free speech. As Michelle mentioned previously, we already regulate some speech. So should this be speech that can be regulated? And he argues that just as with other speech, it would be appropriate for medical board to take action if a physician is spreading information that they know to be false or with reckless disregard for whether that information is true. On page 10 of this 26-page paper, he sort of explains that, and under the Medical Practice Act, as we had argued, and with no license for disinformation, and that there are, in fact, laws in some states that already explicitly give them the authority to do so. So there are organizations who include physicians or are physician-led or made up entirely of physicians, which include America's Frontline Doctors, the Frontline Critical Care Alliance, the authors of the Great Barrington Declaration, one of whom is at your institution, the Unity Project and the Urgency of Normal are all organizations who have intentionally spread misleading information. Now, I can't know for sure what the people involved in these organizations know or don't know. I know what they should know as physicians, but I can't say with certainty what they do know. But I can be certain that at a bare minimum, they are spreading information with reckless disregard for whether or not it is true. And that is perfectly exposed by that clip that I shared that's on ABC, where effectively Pierre Corey says, He doesn't care what the studies say about ivermectin. He doesn't care if it's true. He believes fundamentally that it works. And so it doesn't matter whether it's true or not, whether it works, he's going to continue using it, advocating for it, and spreading that information. That is explicitly reckless disregard for whether the information is true. Now, saying ivermectin works isn't necessarily, isn't specifically anti-vaccine, but it's important to understand, and this is something we can go into in the Q&A, because I don't want to take up too much of the time, but the ivermectin narrative has been part of the anti-vaccine narrative from the beginning. These are coordinated campaigns. These are all interconnected. And the idea from the beginning has been that we don't need vaccines. And so let's find something that is effective at prevention or treatment instead. And so continuing to propagate the narrative that ivermectin works is specifically a part of the anti-vaccine movement and part of the anti-vaccine campaign. So it is directly causing harm, whether or not they want to try to make the argument like, oh, well, we're just saying you can treat something and it's proving to not have any effect. Okay, it's not having any effect. So how is that causing harm? Well, it's causing harm, one, because it can be toxic and we have seen those harms, but the other is it's causing people to believe that they don't have to get vaccinated. That is where the harm is coming. So that is how you can argue that this is reckless disregard that is causing harm. Now, as Mallory already mentioned, we all need to play a role. We all need to learn how to push back. And I appreciate all the work that you are doing, all of you, in understanding how to be advocates, how to speak up, how to use your voice and lend your voice to these conversations. And it's critically important that we understand how to do that. So I want to point all of you to the ideas of pre-bunking and debunking. And again, I'll share all these slides. These resources are directly linked. Pre-bunking is the idea of inoculating people to misinformation. So preparing them, instead of having a deficit of information, you give them the information to combat misinformation as it comes. And then debunking is harder. It's already sticky. It's especially sticky when physicians do it. That's why we believe physicians specifically need to be held accountable for medical misinformation. But debunking, this debunking handbook is excellent. It is actually designed around the ideas of combating misinformation around climate change, but it applies no less to medical misinformation. And then all of us need to speak up to our state and national representatives. As I showed, state legislation is going to be significantly problematic. Obviously, nationally, this is an issue, and more organizations need to be involved. The American Board of Emergency Medicine, Internal Medicine, and Pediatrics haven't yet done anything other than make a statement, but that's only 3 organized medicine institutions, right? There are many more certifying bodies that could be involved and could take action. So make sure to push people where you can, where you are involved, to start tackling this issue and taking it more seriously. So anyways, I want to make sure we have time for questions, and you can always send me an email or a direct message on any of those social media platforms.
Amazing. Thank you so much. I'm going to turn it over to Santiago now for the Q&A.
All right. Thank you to all our panelists for those excellent presentations. Especially, I think a lot of our audience is going to be graduate students in the life sciences and medical students. So having especially presentations on the legal framework and also the legislation that's currently being considered in various parts of the country is really fascinating. I'm going to read from the Q&A and also some questions that were submitted beforehand or that I have in front of me. And the first question I have is for Professor Mello. So one thing you discuss is this idea of effective alternatives or counter speech. And Edward Nirenberg in the chat asks, does effective alternative mean any demonstrable effect, or does it somehow have to be non-inferior to the condition of restricting free speech? So this is, I think, a very medical or scientifically framed question. But also along with that, I think along the same lines is in the marketplace of ideas where this is relevant, there's not exactly, people don't exactly have equal access to the marketplace of ideas. In particular, there are very well-moneyed interests that can influence the marketplace of ideas. So how do these things interpret the court's interpretation of what is an effective alternative, what is counter speech, and when is it, I guess, acceptable as opposed to implementing a restriction?
Yeah, great questions. Maybe since the second one really is interlaced with the social media platform issue, I'll let Evelyn have a whack at that, but I can speak to the first one maybe. So in theory, courts are looking to see whether the proffered alternative policy would advance the government's interests as effectively as the speech restricting policy. Now, like the language that you used of like a non-inferiority trial, it would be delightful if courts approached that evaluation with anything close to that level of precision or specificity. They don't. Typically the language in these cases has a couple paragraphs throwing out some ideas. Maybe they were suggested by the litigants, maybe they were the court's own ideas, and saying, this seems like it would also work. And that's it. No evidence need be proffered. And one of the things that makes this area of law so frustrating for people who work in both law and public health is that some of the alternatives that get deemed to be effective are simply laughable. For example, there's another case involving drug companies' off-label promotion of drugs, which the FDA, wanted to take action on as misbranding. And the court said, well, if we're really concerned about a dangerous off-label uses of drugs, why don't we just cap the number of prescriptions that a physician can write in a year? No physician would say, oh, that'll solve the problem. That's a well-targeted solution that addresses the government's interest in addressing misleading speech about drugs. But that's the kind of level of generality that the court's analysis has. So again, I'll let Evelyn address this question of like in the age of social media, the entry to the marketplace of ideas is not a level playing field for everybody.
Yeah, I mean, and it's one of the other questions that's in the Q&A box too about like the difference here is that anyone can reach millions of people at the tap of a keyboard, which is something distinct about the current information ecosystem than it has been in previous years. And it raises, a number of different issues. I mean, one of the things that we see a lot, and there's been some work, particularly Yochai Benkler and co-authors at the Berkman Klein Center at Harvard, where they've shown that actually a lot of the time it's the top-down mis and disinformation that's doing the most harm and spreading. So we may think of this as a real bottom-up problem that, this is like conspiracy theories coalescing in the dark corners of the internet, but often the times it's like, I don't know, the president of the United States or people on cable news, right, that are spreading information that would have those megaphones regardless of social media. And social media is certainly amplifying the harm and certainly can do certain things itself. But those megaphones are a problem still, and it's not necessarily so much a bottom-up phenomenon as we might think. But I do think that there's the speed of dissemination is a real problem, because I think all of us at various points talked about the fact that once something's out there, it's really hard to dislodge. And I think that then opens up some different solutions that we might think about introducing friction into these platforms. So if the problem, as Michelle was talking about, is like the content-based laws, the problem is that you're targeting specific things and saying that's not true, and that really triggers First Amendment problems. Well, maybe we can look at like content neutral laws that say if any post is moving this quickly, this many people are seeing it, this many people are sharing it in a certain period of time, maybe let's put a little bit of a friction in there, have a stop so that fact checkers can take a look at it, or we can label it more quickly or things like that before too many people see it. So those kinds of solutions, those content neutral solutions, I think are something that could be really fruitful and could be more likely to survive constitutional scrutiny.
Yes, thank you so much. I think you hit on like 3 different questions that are in the list. So really, really high yield answer. Next question is for Dr. Nichols. I think that, especially thinking back to the beginning of the pandemic, a lot of the misinformation starts to spread in a very information poor environment, as you suggested. And I'm wondering if we're trying to think about holding people accountable when it is just in fact the case that we just don't know a lot about what's going on, how do we do that? And how, as medical professionals, given what we know?
I think that's an excellent question. I think that's tough to do, right? If we don't know the information yet, how can we even determine what is misinformation? There are some things that are obviously misinformation and are obviously intended to be misleading, right? We've seen this with, for example, the anti-vax movement over the last couple decades, where just making false, misleading claims out of thin air, right? Like pseudoscience has always been there. We know these things are untrue, but it is hard. You can't get into the specifics, right? Early on, we just didn't have enough information. Some people were theorizing that steroids would be harmful, right? We wouldn't want to label that misinformation because it turns out dexamethasone showed an 18% reduction in mortality. That would have been bad if we had called that misinformation from the beginning and led to increased mistrust in, say, platforms who are regulating that, as Evelyn showed us. So I think that's pretty difficult to lay out in terms of the specifics, but I still think we can act on information that is obviously intended to mislead. I mean, people making claims that are so absurd and far-fetched, like people are now claiming, including physicians like America's Frontline Doctors, that the vaccine contains HIV. That was never going to be true, right? So that from the jump, we can say, nope, like that's misinformation. That is disinformation. That's intended to mislead and cause harm. But I think we do have to, unfortunately, at the beginning, take a little bit more of a hands-off approach and say, we just don't know yet. But the data is there now that we have enough information that we can say things are untrue, that we know, we have proven are untrue.
Thank you, Dr. Nichols. So it is 3:02. So I do want to take a moment to thank all of our panelists for being with us. And we're gonna, I think we're gonna plan to stick around for a few more minutes to ask a few more questions. But if anybody needs to go, including the panelists, thank you so much for attending and for contributing. It was really great. So yeah, thank you. And if you have to leave, feel free. I'm going to ask one more question to Professor Mello because I know she has to leave us soon. But in your chat, were you talking about the legal framework for holding people accountable? It sounds kind of like it would be perhaps a third party that would determine whether or not the harm is being caused by a certain kind of speech or by a certain kind of misinformation. And I'm wondering, in your vision of legislating this properly, how would we decide what is misinformation? What criteria would we use in the court to do that?
Yeah, good question. So assuming that we're thinking about a criminal law of some kind, whether misdemeanor or something else, usually the law will state a standard of behavior that is illegal, and constitutionally it has to do so with enough specificity that a person is on reasonable notice about what is illegal. And then a prosecutor makes a decision about whether to charge the person with the offense. And the prosecutor makes that decision by comparing the conduct with what the law says, and as well as surrounding facts and figuring out, is it likely that I'd be able to prevail on showing that they breached this standard? And, are there mitigating factors that would lead me to exercise my discretion not to prosecute, because it is a choice. So that's kind of the second line of defense, so to speak, against like overbreadth. And then ultimately, it is the adjudicator in a court of law that makes that call, which is usually a jury. But again, for misdemeanors or other kinds of offenses, it might be a judge. And then, of course, an appellate court down the road will look to see indeed was the standard laid out in the law met by what has gone on here. So there are several layers of adjudication, and as with all crimes, that is meant to protect people from being successfully prosecuted for conduct that does not clearly over the line. What makes this challenging is that, unlike a lot of other criminal offenses, there's just a lot of gray. No matter what standard we wrote into the law, there would be lots of room for interpretation. And it doesn't make this unique, but it does make it one of the harder types of conduct to try to prohibit.
Yeah, thank you so much. My next question for now Professor Douek is, given that we value academic freedom so much in our institutions, how do we gel that value with, for example, wanting to have a social media environment that's not rampant with misinformation, or holding people accountable for misinformation?
Easy question. Yeah, I mean, I think this is the big question of the moment in many ways. It's sort of a question not just about medical misinformation. It's a question more broadly about how do we combine speech norms in the new social media era with academic freedom and these problems that we're facing in a variety of different contexts. And I think for many that's a question that can't really be answered in the abstract. I think is too difficult to distill some real general principles about academic freedom versus misinformation. I think it's going to be really context specific. It's going to be a really, I think that academic freedom is vital, and I don't need to tell all of you. I think Mallory opened with that's what science is about, and exploration. At the same time, Taylor's outlined a number of examples of where authority can be misused as well. So I think that's going to depend a lot on the context, who the audience is. We often talk about these things in the abstract of like a public audience, but if an audience is a scientist or more informed or has a better ability to do their own research, for example, that might be we might want different norms in those contexts as opposed to others. There's also going to be cultural norms around this as well. Like we've been talking about this in the context of the United States, of course, which has its own particular conceptions of academic freedom and freedom of speech in the First Amendment. But of course, as we all know, this is a global issue. And so I'm just going to duck that question basically and say, we need to think about that in much more concrete terms than just as a general question.
Yes, thank you. Yeah, it's definitely very, very challenging in the modern era. And Dr. Nichols, Professor Stephen Goodman, I think had to go, but he asks a question here: is why is it such a part of disinformation movements to promote bogus remedies as opposed to legitimate treatments? So, for example, if your goal, E+ is a goal, if you don't want to take a vaccine, but now we have Paxlovid and antibodies, why aren't those the ones that are being promoted? What's the underlying cause, do you feel?
I think part of that was timing. Like Paxlovid and monoclonal antibodies came after all of these other ideas were thrown out. After hydroxychloroquine was, debunked as being ineffective, after ivermectin, which only now finally has papers more definitively proving that it does not work. But Paxlovid just recently, during Omicron, has become available and is shown to be effective. We're 2+ years into this. So part of it was what was available as a therapy, as something that had caught the national interest and was part of the conversation, and just pumping that as hard as they could. But that's also not to say that like monoclonal antibodies were a huge part of the disinformation campaign, right? Ron DeSantis basically said, nope, we have this available. Nobody has to do anything, no restrictions anymore. We're going to buy a ton of monoclonal antibodies and make it available to everyone for when they get sick. Not to mention the conflicts of interest in the fact that he, had financial stake in Regeneron's success, but that was definitely part of the conversation. So I wouldn't say that it was not involved at all. It played a much more minor role because that came later than these ideas of hydroxychloroquine and ivermectin.
Thank you. Okay, so I think with that, we're a few minutes over time, but I want to thank again all of our panelists for joining us.
Can we close with one last quick question, like 20-second answers from everyone? Because I feel like a lot of this conversation has been about sort of like institutional solutions. So if you have any thoughts on, you know, even though this isn't going to solve all of it, individual actions and like whether it's advocating for changes in each of these arenas or counter speech, like how can we be effective individually in combating misinformation? And why don't we go in order of speaking? So I'll pass it to you, Professor Mello, first.
Well, I mean, you know, I expressed a lot of pessimism about our ability to debunk vaccine misinformation claims, but I do think that there is one constituency that has had some success in doing so, and that is pediatricians and primary care physicians who are entrusting relationships with patients already. So particularly given that we should not expect any governmental restrictions to stop the flow of this garbage, it is all the more essential that people who are in those trusting clinical relationships get trained and skilled in the art of motivational interviewing with their patients and patients' parents.
So as Gandhi said, be the Twitter that you want to see in the world. I think all of us probably, you know, get the urge to tweet or retweet before we have fully, you know, investigated or, you know, ascertain the truth of things, especially in fast developing events. And you know, we all like the clickbait and the engagement. So I think that, you know, it's a very minor thing. It's not going to definitely, as Mallory said, not going to solve everything, but I do think we all have a part to play in helping develop better norms around what we share on social media.
As Michelle mentioned, I have had more success. Well, more is relative to almost zero, I guess, in changing people's minds on, say, Twitter versus in real life. So when I have real interactions with patients, even though as an emergency medicine physician, I generally don't have an established relationship with a patient when they come to me. Some of them I know because we see frequently, but most of them I don't. And even in those short encounters, I've had much more success with changing people's minds or engaging in reasonable discussions on a face-to-face level where somebody can see me, see that I care, hear, you know, see that I am hearing them and know that they are being heard and that I am providing them the best information that I can. In those conversations, I have had much more success. So I would say that is exactly right. Engage with the people you know, with your community. That's going to be where you're going to have the most success in changing hearts and minds.
Thank you so much. Okay, so now let's close, and thank you all for coming, and thank you all so much for contributing. It was a fascinating event. I hope everybody has a good day.
Thanks very much.
Thank you all. Stop.